This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court stepped into the 2024 election, allowing Virginia to carry out a purge of residents from its voter rolls. The court's conservative justices granted an emergency appeal from Virginia's Republican governor, despite the fact that a federal court had found that the state had illegally purged more than 1,600 voter registrations in the past 2 months, violating a 90-day pre-election quiet period under federal law. The 3 liberal justices dissented. Virginia Governor Glenn Youngkin has defended his order issued on August 7th, the 90th day before the November 5th election. Here he is on CNN.
Because it is done on an individualized basis, person by person, and because that person has in fact self-identified as a non-citizen, this is not subject to the 90-day blackout period, in my view, and in counsel's advice.
Joining me is election law expert Richard Briffault, a professor at Columbia Law School. Were you surprised that the Supreme Court intervened to reverse the Fourth Circuit and the district court judge?
Yes. Maybe I shouldn't have been, but yes, I was. So this case involves a state effort to purge people from the rolls on the claim that they're non-citizens. Non-citizens are not entitled to vote. It's illegal, and states are allowed to remove any non-citizens that are on the ballot. But there is a provision in federal law, National Voter Registration Act, that prohibits mass purges, so-called systematic purges, within 90 days before the election, because it makes it too difficult for people maybe purged by mistake. And if it's a mass purge, it's actually difficult for people to be aware of that and to respond. And so that is illegal. But Virginia consciously adopted such a program. The governor issued an executive order to that effect, literally on the day that this so-called quiet or non-purge period was supposed to begin. And basically, it used some mix of DMV data and other databases to conclude that people were not citizens. DMV, when you get a driver's license, you may be asked whether or not you're a citizen. Some people check non-citizen by mistake. Some people check not a citizen because they are not a citizen when they get their driver's license, but some years later become naturalized as citizens. So the state, using that data and other data, went ahead and concluded that something like 1,600 people were not citizens and needed to be purged from the rolls. And that was challenged on the theory that it violated federal law, and also there was evidence that a number of these people who were purged were in fact citizens and were challenging them as individuals. The federal district court in Virginia concluded that this was a pretty straightforward violation of federal law, that it was going on in this so-called quiet period, that it was a systematic removal effort not based on individualized information about individual voters, but basically a massive database information that they were loading from one database to another. And the Fourth Circuit Court of Appeals agreed, rather refused to overturn the district court's injunction. The Court of Appeals basically said, yes, on the facts, it appears to us that this is a violation of federal law and it should be stopped. The Supreme Court, rather quickly, I'm tempted to say 6-3, but you know that 3 liberal justices dissented because it was just an order. It's not clear that all 6 of the others agreed, but it looks like by pretty much a party line vote, without an opinion, basically reversed the Fourth Circuit and allowed this purge to go forth. The purge is actually stopped, but the 1,600 voters who were removed remain removed unless they can, as individuals, go in, and Virginia allows the same-day registration, go in and prove that they are citizens and re-register and then vote.
Virginia made several arguments, and one was that the quiet period doesn't apply to non-citizens. Another was that courts shouldn't get involved because of what's known as the Purcell principle.
Right. So taking them in reverse order, the problem with the Purcell principle in this case is courts cannot get involved. I mean, the only basis for judicial intervention is that the state has violated the 90-day rule. So any effort to enforce the 90-day rule would occur within 90 days before the election. So it makes no sense to invoke the Purcell principle here. The only real question is, did the plaintiffs and the U.S. government, which also participated, move quickly once they became aware of what was going on? And the lower courts agreed that they did, that there was no delay. Once it became clear what the state was doing, the lawsuit was brought. In terms of whether or not the quiet period applies to removal of non-citizens, nothing in it indicates that it doesn't. In other words, the law is simply there to say that there should be no removals based on a system, no systematic removals. And it doesn't say no removals only for non-residency or no removals. It just says no removals. that period. So there's nothing in the law that limits the grounds of ineligibility to something or other, like such as to moving. And it does permit removals for death. So it's not quite clear what this law would be doing if it doesn't also apply to removals on a theory that the individual is not a citizen.
So, as you mentioned, we don't know why the justices voted as they did, but the three liberal justices made their public dissent clear. Mm-hmm. What does it tell you that this was down ideological lines?
It's very troubling. It's very troubling, the decision. It seems to be the lower court decision was well-reasoned. The Court of Appeals agreed with it. And there is irreparable injury to those voters who might be eligible to vote who've been denied the right to vote. Now, some of them will be able to reestablish their eligibility because they can re-register in the coming days. So it's possible some of them will be back in. But, it takes time, it takes effort. It's quite possible some of them will not.
Although Virginia is not a battleground state, this was based on an order by the Republican governor and was backed at the Supreme Court by the country's 26 other Republican state attorneys general, the Republican National Committee, and several conservative groups. And it revolves around a flashpoint in Donald Trump's race, which is that, there's widespread voting by non-citizens.
Right, and for years he's been making that argument. Even when he won in 2016, although he lost the popular vote, he says, well, I really won the popular vote because Hillary Clinton's numbers were inflated by all the non-citizens. There is absolutely no evidence of more than a minuscule number of non-citizens voting, and usually it's by mistake. It's illegal for non-citizens to vote. There are severe penalties. The number of non-citizens who are registered to vote or actually vote is absolutely minuscule. It is a non-fact. But it's been used so heavily by Republicans to try and undermine the legitimacy of the election. There is just no evidence that it occurs.
So do you think this lawsuit is to set the stage or the groundwork for contesting election results?
Yes, I think anything that raises the issue of non-citizens. Now, of course, Republicans won this lawsuit, so they won't be able to make this argument in Virginia now. But, it is an issue they've been raising all over the country. There was a similar dispute in Alabama where the federal district court ordered the governor to stop the purge program in Alabama and to undo it. And there I think about 3,000 people had been removed from the rolls. And there was evidence, again, that it's often by mistake. Again, they're using old databases. Sometimes it's the wrong person. There may be that the DMV numbers may indicate that this person with a certain name is a non-citizen. Somebody with the same name but a different person might be removed from the rolls because of their matching is pretty basic. Basically, if you have the same first and last name as the person who's been identified as a non-citizen, you can be removed, and that's not so uncommon. And it also, again, using DMV data, since your driver's license can be good for 4 years or more, in that time you could have naturalized from being a non-citizen to a citizen, but that naturalized person will be removed from the rolls. And so I think it's very much a way of keeping the issue alive and in front of people all the time. And indeed, people will think, oh, there were 1,600 non-citizens voting in Virginia. It's not clear that any of them were non-citizens. Certain number of names popped up on certain databases, and certainly there have been individual cases in the newspapers of people showing that they were not non-citizens, that they were citizens. Some citizens from birth and some naturalized citizens.
A lot of election experts have been saying that this year's election won't be a repeat of Bush v. Gore. The Supreme Court is unlikely to play a pivotal role. But does this decision indicate differently that the justices may get involved?
Yes, I don't know why you would think that the justices will be uninvolved. It will turn on what the issues are. And, I think Bush versus Gore was unusual in that the issue the Supreme Court dealt with was, in fact, a post-election issue. In other words, how to take care of a recount or how to take care of the counting of ballots in Florida where it wasn't completely clear how people had voted. And so that was an issue that could not have come up before the election. This time, I think it's still another week to go. They're deciding issues that could be relevant to the election beforehand, like this one. As for things after the election, there may still be things that come up. So it's hard to know. In some ways, you could argue that the decision earlier this year on Trump's immunity in some sense plays into the election, or he's getting on the ballot in the first place. So I don't understand the argument as to why anyone thinks that they would be more or less engaged than in 2000 or in 2020, where they did a bunch of things before the election, but not so much after the election.
Right. Well, they point to that. They say all those, more than 60 cases brought by Trump and his allies, and they didn't take up any of them.
Right. And including the original jurisdiction case that Texas brought against Pennsylvania to not count Pennsylvania's votes. Texas joined by 20 other Republican states. They didn't hear that. No, they stayed pretty much out of it after the election in 2020. But, the result in 2020 was pretty clear. I think it's hard to speculate about the Supreme Court, but this decision is not a great sign about the courts wanting to stay out of the election. This was an unnecessary decision. The law was pretty strongly on the side of the plaintiffs, the ones trying to stop the purge.
They did refuse to order RFK Jr.'s name removed from presidential election ballots in Michigan and Wisconsin.
Yeah, I mean, again, it's hard to figure out. I mean, it could be that maybe they want to be deferring to the states both ways. I mean, refusing to order the removal is consistent with the state, and in this case, allowing the state to go forward with the purge is consistent with the state. Maybe that's part of it, but I'm not even trying to attempt to say that there's a consistent logic.
It's hard to see it. Maybe we'll understand more when the court rules in a case in the pivotal state of Pennsylvania, where the Republican Party is trying to get the justices to stop Pennsylvanians from getting a second chance to vote if their mail-in ballots are rejected as incomplete. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. Coming up next on the Bloomberg Law Show, a Texas judge's unusual request injects culture war issues into the Boeing plea deal. I'm June Grasso, and you're listening to Bloomberg. The U.S. government's criminal case against Boeing over 2 fatal crashes took what many legal observers called an unusual turn when a conservative Texas federal judge brought the culture wars into it, questioning how diversity practices would affect the selection of an independent safety monitor. Judge Reed O'Connor, a George W. Bush appointee, is considering Boeing's proposed plea deal with the Justice Department, which would allow the company to avoid a criminal trial over the 2 catastrophic crashes of its 737 MAX jets. At a recent hearing, the judge pressed the Justice Department on why diversity, equity, and inclusion criteria in the selection of a monitor had been built into the plea agreement. Joining me is Todd Haugh, an associate professor of business law and ethics at Indiana University. First, tell us where the independent monitor fits into the plea deal.
So the Department of Justice is part of the proposed plea agreement in the Boeing case, has a provision in that agreement that says Boeing will be under a corporate monitor for the next number of years. And a corporate monitor is essentially an outsider that will be involved in day-to-day decisions that the company is making in order to ensure that they're going to beef up their compliance program and make sure that essentially they're following all the compliance obligations that are laid out in the plea agreement in order to repair essentially the wrongdoing that has occurred that caused the conviction.
And what made this judge curious about diversity, equity, and inclusion criteria?
So to take a step back for a second. So first of all, it's very rare for judges to have a whole lot to say about corporate monitors because usually the agreements between a company and the Department of Justice where a monitor would be imposed don't really get in front of judges very often. So this is kind of a atypical situation because there's actually a plea agreement in this case. And so because there's a plea agreement, now the court has the opportunity to either accept or deny that agreement. And so as part of the court's role, the judge was reviewing the proposed plea agreement, which has been particularly contentious because the victims of the 2 plane crashes have been trying to block a plea agreement for a very long time. They want to go to trial. They want Boeing to be held responsible. So in order to decide whether the plea agreement is going to be granted, the judge was reviewing it. And what happened recently is the judge wanted to get more information related to a diversity and equity provision related to the monitor, which is essentially a Department of Justice provision that says, we're going to make sure we're going to look at diversity and equity issues. We want to keep those in mind when we're selecting monitors. And that really caught the attention of the court.
The Justice Department says this is really part of a long-standing practice at the agency. Quote, this new language reflected not a change in policy, but rather a principle that has always governed the process. That selection of a monitor must be based solely on merit from the broadest possible pool of qualified candidates.
Let me put this in a little bit larger context. So this diversity and equity provision has been in Justice Department, policies, has been used related to monitors going back quite a way, since about 2018. Hasn't been used a lot in every single monitorship, but it's been around, and then it was kind of more formalized a little bit later. So there's been a number of years that this provision has been out there. The purpose of it was to try to get a more diverse pool of monitor candidates, because if you look back at the history of monitors, they tend to be lawyers from big law firms and big consulting type firms, former Department of Justice, officials or prosecutors. They tend to be older, they tend to be male, and they largely were white. And so, these kind of DEI provisions were sort of just a larger effort by the Department of Justice to diversify the monitor. It doesn't necessarily mean you're going to get less qualified candidates by any stretch, because there's a lot of great qualified candidates. I think the issue here is, we're in this political moment where diversity, equity, and inclusion, so the pendulum is swung back. And this judge is picking up on that and really focusing closely at it. However, my opinion here is the judge should be focused more on the qualifications of the monitor, not necessarily the DEI provision, but this larger question of what type of skills is this monitor going to have? I think that's where his focus should be.
But normally, as you said before, judges don't get involved even in the selection of the monitor.
That's correct. So the way that the Department of Justice policy for monitor selection generally goes is the DOJ and the company selects a bunch of different monitors, and then ultimately the Department of Justice sort of selects one, and there's some kind of like veto provisions, if you will. This particular monitorship is a little bit different, where the Department of Justice has created more of an open call for monitors. So anybody really is going to be able to, assuming that the judge approves the plea agreement, anybody is going to be able to put their hat in the ring to be a monitor, and then the selection process is a little bit different. But all of that is sort of, in some ways, kind of gone by the wayside, because the judge was really focused on this DEI provision in particular.
Did you find the Justice Department's explanation convincing?
Well, listen, I think that the Department of Justice, I think they're accurate in what they've reported, in the sense that this provision's been around for a long time. They give the background about why the provision was created. They're absolutely right, too, that these provisions have been in effect over the last two administrations, so not just the Biden administration, but also the Trump administration. So, it's been kind of a fairly long-standing practice, despite the focus on it now. Again, my focus here, if I were the judge, is I would be asking much more specific questions about, well, what exact skills and expertise is the Department of Justice wanting, and is Boeing going to agree to, essentially, in order for there to be an effective compliance program to make sure something like what happened with the Boeing case doesn't ever happen again. And so there's been a lot of problems with skills and expertise of monitors over the years, and that has had nothing to do with diversity, equity, and inclusion, because we've seen those problems before this DEI provision was in place, and we've certainly seen them afterwards. So that's what my focus would be if I were this judge, and that's what I would counsel him to be looking at.
Well, Judge O'Connor has been known for some very conservative opinions. He's the judge who found Obamacare was unconstitutional, which the U.S. Supreme Court then reversed him on.
Yes, that's right. I wasn't familiar with his, ideology prior to this. And so, I guess the cynic out there could say, well, listen, this is kind of just part of his particular predilections or his ideology sort of entering the culture wars or something like that. Whether that's the case or not, I think what we really need to be focusing on is the purpose of the monitor. The purpose of the monitor is to be involved in the company to help ensure that the processes the company puts in place going forward are going to actually solve the problem. And that's really what we need to be focused on if we want to have a real impact on corporate wrongdoing and corporate crime and positive cultures in an organization, which Boeing really is suffering from the negative effects of. And you can see that in the safety records and a whole lot of other things going on at Boeing. So getting a good monitor in there that's actually going to make a difference really matters. The demographic makeup of that monitor shouldn't matter. It's really about the skills and expertise. And so that's, again, where I would want this judge to be focused as opposed to entering the culture wars or making some kind of statement about DEI more broadly.
So the judge is going to decide on whether the plea agreement goes forward. And in that, he could say, I don't want a monitor that is chosen by using diversity, equity, and inclusion criteria?
Well, it's kind of interesting. This particular plea agreement comes under a provision that's called a C plea, which basically says that the parties have agreed on the plea, and the court is going to agree to it or not agree to it. It's kind of a take it or leave it situation. And then if the judge didn't agree with it, the parties just sort of have to go back and see if they could figure out something else, or they could decide that, they're going to go to trial. So it's an interesting way that the court kind of put its foot in the door about this particular plea agreement. My guess is that ultimately it gets approved because that's what happens in the vast, vast majority of these types of cases. But it sure seems that the court's going to put the parties in the Department of Justice through the ringer, if you will, on this DEI provision and maybe some other provisions before that happens.
Because the opposition to this by the victims' families has been, very loud and persistent.
That's exactly right. It's part of the really uncharacteristic nature of this type of case where you have a really vocal victims group that doesn't always happen in white-collar, corporate crime cases, and they have a extremely able counsel, Paul Cassell out of the University of Utah, who has really led the charge. And so not only did they block, sort of reopen the case, if you will, and had the Department of Justice relook at the existing deferred prosecution agreement. And that's sort of what, led to now there being an actual formal plea and going to be a conviction in this case. So, yeah, it's a very unique experience. And I think from their interest, right, they're happy to have anything that's going to disrupt the plea agreement because ultimately they want either a more stringent plea agreement that goes against the company, or they want the company to go to trial and face the consequences of the trial.
So under the plea agreement, what exactly happens to Boeing?
Well, Boeing would pay a massive fine. They have long-term compliance obligations, how they have to remake their compliance program in order to guard against this type of fraud. And then kind of included in that, there is going to be, a corporate monitor that will oversee those changes within the company for a number of years going forward.
Thanks so much for being on the show. That's Todd Haugh, a professor at Indiana University. Coming up, why New Jersey's Supreme Court is so different. This is Bloomberg. Next week, voters in nearly 36 states will select hundreds of judges who will be asked to resolve contentious political questions about issues like abortion and gerrymandering. And partisanship has crept into, if not overtaken, judicial elections, with special interest groups spending millions on the races, especially when the flip of a state's Supreme Court could lead to monumental reversals of law. That's true everywhere except in New Jersey. Here to explain why is Alex Ebert, Bloomberg Law senior correspondent. Start by telling us about the record of the New Jersey Supreme Court in the last 2 years.
The New Jersey Supreme Court is amazing in how consistently it has been unanimous over the last several years. In the last 2 years, in roughly 90% of their decisions, they have no concurrences or dissents. They speak with just one voice.
And is the court divided 4-3 based on political affiliation?
It is, yeah. So for the last 2 years, up until just a month ago, it was 4 Democrats and 3 Republicans. Now there are 4 Democrats, 2 Republicans, and 1 conservative independent, who was the former Attorney General for Governor Chris Christie.
And how are the justices chosen?
The justices are chosen in a unique way. The governor gets to nominate them, but the New Jersey Senate, which has been controlled by Democrats for 20 years, has something really similar to the federal blue slip system. The senators that are from the area where the candidate lives have a veto check on that nomination getting a confirmation vote. Sometimes that can mean up to 5 different senators have to be won over by the governor. And they use this to extract different things from the governor, whether it be budget things or nominations of their political allies to other posts. And because of that, these nominees usually have a really high caliber and can please many people across the state.
I mean, if you have a Democratic New Jersey governor, why is he not appointing all Democrats, let's say?
That is a question I came into this with and was totally blown away what I found out. For the last 70 years, the governors of New Jersey have relied on this old tradition, an unwritten rule that says the court is going to be max 4 justices from one political party. It's always balanced on a partisan knife's edge. And what that does is it creates this system where unanimity and collaboration are a lot more important, because just one switch of the governor can change who controls the majority on the court, because that person will get the chance to possibly nominate, the next vote that could flip it from Democrat to Republican. And so you see these justices working together more collaboratively because of this unwritten rule. It's not written in their constitution, not written in any statute.
It is sort of amazing that it's unwritten and everyone has still been following it. And New Jersey is a reliably blue state?
It has been for the last 20 years, at least in the state legislature. But the governorship isn't that way. You saw Chris Christie have 2 terms before the current Democratic governor, Phil Murphy. So there's definitely the space and ability for a moderate Republican to take over that governor's post. And when they do so, they have to collaborate and work with that Democratic Senate in order to get these people on the bench. And it extends even further than the state Supreme Court. The state Chief Justice, he has this unique power in the whole country to balance out partisanship on the state appellate courts. And it's expected to have partisan balance at the trial level as well. So you see this all the way down, like Russian nesting dolls of partisan balance across the state.
And just to compare, let's talk about judicial elections in some other states and what's happening this election day.
Roughly 36 states are going to be selecting judges. It's more common to have judges elected than appointed. And these races, you're seeing millions of dollars from dark money groups pour into them to get justices with their political or ideological, legal persuasion on these benches. We saw just last year a $31 million race in Wisconsin, the highest ever, and it's expected for money to be a really big player in these elections in states where abortion is, decided at the last line by these state Supreme Courts.
And explain what's happened in Wisconsin, because that seat changed the composition of the court.
Yeah, so Wisconsin's an interesting case, but not unique. I've covered judicial races for several years for Bloomberg, and you see in Wisconsin, like you see in North Carolina, how a shifting court will literally overturn decisions that were issued months or recent years previously. So in Wisconsin, you had Justice Protasewicz, a Democrat, win her spot onto the court, replacing a Republican, and that allowed the court to overturn things like ballot drop box access and political gerrymandering. That's a really hot button issue in the state. Compare that to North Carolina. Over a couple elections, you saw conservatives take over that state Supreme Court, and they reversed things on election law, and they actually eliminated partisan gerrymandering claims there after a liberal court had just recently said that folks could bring those cases.
Let's talk about how the justices on the Supreme Court in New Jersey choose their cases.
Yeah, so the funnel in New Jersey is really interesting, right? You think about like pouring oil into a car, right? And it's got to go through a funnel. It's the same kind of thing with cases in New Jersey. You start with this wide funnel and it gets narrow really, really fast. When you appeal a case in New Jersey, it goes up to a unitary court of appeals. That means that, it'll go to a single body and the different panels. All of their cases are precedential on each other. That's different from some states you consider like Ohio, where you've got more than 10 different regional courts of appeals. There, the law is a lot more chaotic, right? But in New Jersey, you have this unitary court of appeals. That means that a case is going to be heard by a panel, and that panel is going to consider the law that everyone else in the state is using. And if that panel has a dissent, they know that automatically means there's going to be review of some kind by the state Supreme Court. So there's a big incentive, even at just the appellate level, for those cases to come out unanimously and have collaboration at the appellate level. Then it gets even more interesting at the state Supreme Court. New Jersey has this process where they have cert partners. So the justices will team up in pairs of two to consider a different batch of, asks from these parties that have cases for the court to give it another look. And oftentimes you'll have a Democratic justice and a Republican justice teamed up together looking at cases, collaborating and deciding if the issues are important enough for the New Jersey Supreme Court to weigh in.
And then tell us about the next step, the conferences the judges have.
The justices, like state Supreme Courts across the country, they will bring their thoughts on the different cert petitions to the broader court at conference, right? And if the justices agree, they'll give like a unanimous thought on whether the court should take or reject a cert petition. And everyone is in the room and the partners are going back and forth. And more often than not, these justices are agreeing. They're already sort of, seeing whether the law and the implications are important for the state before the court even hears the case. And Chief Justice Stuart Rabner, he's a Democrat. He sits out of the cert partners process. So you have 3 Democrats and 3 Republicans looking at these cases ahead of this meeting. But he'll come on in and he'll weigh in on whether the state should take cert petitions.
In your story, you talked about the tenor at oral arguments.
Oral arguments, when you're listening to them, and I've listened to hundreds of them across the country, they can feel like a dodgeball game, right? You've got, people being pelted with questions from all sides. Sometimes the judges are even trying to undercut each other, with their questions and, advance the legal theories that they're focused on. That is the opposite in New Jersey. The folks have talked with me that are longtime litigators appearing before the court for 30 years or more, and they've said that it verges on kindness, not even just civility. So you'll see things like the justices will accidentally interrupt a litigant while they're talking, and the justice will actually apologize to the litigant and say, sorry for interrupting you. It's wildly different than you'll see most other places where the justices are seeking to interrupt the different lawyers. Another thing that's unique is they are extremely long. I just listened to one last week that went over 3 hours.
Wow.
And at the end of the argument, Chief Justice Rabner, he has this thing that he always does where he asks the lawyer if they have anything else they'd like to say. And so it drastically changes the way these cases are presented to this panel.
I like this part where the litigators who appear before them say that they're not even trying to count votes anymore.
There's no more nose counting in terms of what these routine and veteran litigators tell me. These are people that are partners at, national law firms that have litigated elsewhere. These are folks that have been in the trenches for decades. And they've seen what the court does and how it rules. And they tell me, I can't figure out ahead of the time where this is going to come down. And so they have to offer up like consensus building opportunities for the court because they know that the court is likely to have these Democrats and Republicans come together on something. So they can't just lead with their strongest argument. They almost have to offer up alternatives that, normally you'd see justices sort of, peel or crank out of people that don't want to offer them up at argument.
So with the Supreme Court, when there is a consensus opinion, it's often narrow. Is that the same in New Jersey?
Indeed. So, off the record, some folks have told me that they really wish that, things could be bigger swings by the court, right? This is generally a liberal state, and, folks on the criminal defense side, wish that this usually privacy and independence-minded judiciary would be more progressive with advancing, criminal rights or consumer rights, but you're seeing the justices come together on narrower propositions of the law. You have a lot more like constitutional avoidance, right, where you lean into a statute in order to, steer clear of murky constitutional questions. You have things where like a court could make a big swing, but really what it's doing is it's getting everyone on board to come to a narrow proposition of the law where it can be more stable and consensus building.
This sounds like a great system, but because it's based on tradition and unwritten law, does it seem like it would ever be implemented in another state?
No, and folks that I've talked with, they said the same. They recognize that it's extremely fragile. We've got a law professor who is a former co-dean of Rutgers University School of Law, and he says in there that, even writing these things down right now would probably make them too political to survive debate. There are some things like the cert partners process, which might be exportable. You have a lot of state courts around the country that might be willing to consider that. But things like the partisan balance at the top of the court, that might be really hard. Over the last century, you saw a lot of states move to the Missouri model for their state Supreme Courts, right? This effort to have some sort of merit selection process to eliminate political corruption, by governors or by political machines. So you have the state bar come in and put forward candidates for governors to nominate. That seems to be sort of the alternative process around the country where they aim for nonpartisan sort of judiciaries. Here you have an outright partisan judiciary, but they're coming together because of these unwritten rules. So it's very unique.
And tell us about the justice who described how fragile this is.
We got an exclusive interview with a retiring justice. His name is Lee Solomon. And he really talked about how New Jersey is one of these states where if we think about how democracy is so fragile, we have this time where politics is really being leveled at the court, and courts are being seen as more political. And New Jersey is a state where, thus far, the legislators and the governors have been able to come together and make sure it doesn't go down the path of other states or federal courts where it really is becoming more of a, gloves-off brawl. But, we're always just one governor looking to pack the court or push it one way or another from this system that's so fragile and tenuous falling apart.
A great story, Alex. Thanks so much. That's Bloomberg Law senior correspondent Alex Ebert. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.